morality in India. So I would love to make a caveat before starting my presentation. I'll be sharing my presentation to you also. I hope all the participants got my presentation here.
Yes, sir.
Okay. Before making the presentation, I would like to make a few observations in the sense I am not making any value judgments because morality itself is a value-laden subject. I am not making any value comments on that, no value judgments on that. I am just raising some of the issues before you. You can ponder over it, you can take decision, or you can arrive at your own conclusions on these issues, because I am not making any value judgments on these things. Since you are all the teachers of the political science, you can just think and ponder over all what I am saying, whether these are the right things or not. You can take the judgment, make the judgments on your own. This is a caveat before I make my presentation. Before going to the constitution morality, what is morality? Morality is of course, it is a philosophical concept. It can be generalized or it can be brought into the layman's words. It is in the works of in the words of Swami Vivekananda. It is unselfish. Which is selfish is immoral, and which is unselfish is moral. Likewise, Mahatma Gandhi says, morality is the basis of things, and truth is the substance of morality. Moral systems, and Jonathan Haidt, he gives us moral systems as such. He says moral systems are set of values, virtues, norms, practices, identities, institutions, technologies, and these are all evolved psychological mechanisms that work together to regulate selfishness. So basically, again, he says, which is unselfish, which these are things are meant for the regulating our selfish tendencies, selfish behaviors. This is what this is. And Dr. S. Radhakrishnan, he makes morality as the king of kings. In his words, much has been said about the sovereignty of the people. We have held that the ultimate sovereignty rests with the moral law. With the conscience of humanity, people as well as kings are subordinate to dharma, that righteousness is the king of kings. So morality is the which is unselfish, which is in a righteous way. What are we doing? Because in all our actions, morality, a thin layer will be there. In human beings, all in his actions, whether in politics, whether in society, whether in economic system, whenever you take decisions, whenever you behave, there will be a thin layer in the human behavior, which regulates our selfish tendencies, which minimizes our selfish things, and which brings us to the righteous path, which is acceptable to everyone, which is good for the society. That is what the morality is there. So it's basically, it is a righteousness or the good path towards the sustainability of the society, sustainability of the system, sustainability of the governance, sustainability of the administration. This is what the morality in general sense. Now coming to the constitutional morality. Constitutional morality has been described by many theorists and many political scientists. I begin with Aristotle. I have given a big quotation, but we can now reduce it to only to, he says, it is an education of citizens in the spirit of the constitutions. So Aristotle says it is this constitutional morality is educating the citizens in the spirit of the constitution, and the constitution is the supreme that needs to be inculcated among the citizens. That is what Aristotle says. And the George Grote, who was writing the history of Greece, he first coined this terminology, constitutional morality. He says, in fact, Dr. Ambedkar also quotes this George Grote's quotation in his constitutional debates. What the Grote says, it is a paramount reverence for the forms of constitution, enforcing obedience to the authorities, acting under and within those forms, yet combined with the habit of open speech of action, subject only to definite legal control and unrestrained censure of authorities as to their public acts. So it has four components. One is it is a paramount reverence for the Constitution. Secondly, it enforces obedience to the authorities, the citizens' political obligation to the authorities. Third one is it is a censure on the authority who are there in the government, who are there exercising political power. It is a restraint on them. So this is what the constitutional morality in the words of George Grote. Ambedkar also, borrowing from George Grote, he says he says two things. One is the form of administration can be changed. It has a close connection to the Constitution. So constitutional morality is not a natural sentiment. It needs to be cultivated, because he was of the opinion that Indian society doesn't have that kind of constitutional temper. That is why it needs to be cultivated among the citizens. He was of the opinion the Indian society is hierarchical, because the soil of the Indian society is not meant for the democratic society. That is why it needs to be cultivated. That is the Ambedkar's views. Coming to Jorgen Habermas, he calls it as a constitutional patriotism. So thus, this all political scientists, they are of the opinion that they think giving respect to the Constitution, reverence to the Constitution, and educating the people in the spirit of the Constitution, this is what the political scientists, express their opinion on the constitutional morality. We have number of Supreme Court judgments. So that also, they also use this terminology, and they also express their views on the constitutional morality. That is why constitutional morality advocated in judicial pronouncements. This was first used in 1973 in Keshavanand Bharati versus State of Kerala case. In fact, in last 2023, this was the Supreme Court celebrated the 50 year of this case, and they hosted a dedicated website for this case, Keshavanand Bharati case. This is such an important case, landmark judgment. In this, H.R. Khanna, again, Justice H.R. Khanna again reiterated Grote's view that further in the goals of democracy, we should have diffusion of constitutional morality. So diffusion of constitutional morality among the community, means among these people, among the political functionaries, among the constitutional functionaries, is necessary. That is what the Justice H.R. Khanna opined in this case. Coming to the another case, Niranjan Hemchandra Sashital versus State of Maharashtra. This was a case concerning with the corruption case. So the Supreme Court made an observation that to mitigate corrupt practices, mitigate the maladministration, we should have the constitutional morality in practice of among our administrators, among our governing elites. This is what this case. In another case, Manoj Narula versus Union of India. This is a 2014 case. This case pertains to the appointing in 2006, there was a government of India appointed one minister with the criminal background, with a heinous criminal background. That time this case came up before the Supreme Court. So that time the Supreme Court said that you have the power under Article 75(1) to appoint anybody as a minister. But you should also have the look into the constitutional aspects. Just not technically anybody can appoint it, but whom you are appointing, if he has a criminal background, if he has a heinous criminal background, such person should not be appointed. This is what this case, the Supreme Court advocated. There should be constitutional morality. Whenever we take any decision, that decision we should take with solemn respect to the Constitution, not just technically or mechanically or legally. We should have respect in the solemn respect, in the sense great respect to the Constitution as such. This is what this case, they say, reverence for the Constitution and its structure should be the prime importance in taking decisions by the political functionaries. Then comes to the another case, NC, National Capital of Delhi versus Union of India. There were a lot of cases were happening. This is a 2018 case. Morality that has inherent elements in the constitutional norms, it is the conscience of the Constitution. He said constitutional morality is the conscience of the Constitution. This is what the Supreme Court has said. In another judgment, in the Justice Chandrachud, he said constitutional actors must see their relations with one another as a constitutional partnership. This is more important. We have the constitutional functionary like the Prime Minister, ministers, President, Vice President, Speaker, so many constitutional functionaries there. They are all partners in running the government. There is that should be the spirit, and decisions on important should be taken consensually for the benefit of the nation, for the benefit of the public as such. And one more thing he says, in the time of crisis, in the time of troubled situation, constitution morality is the compass which gives the direction to us, which gives the direction to the constitutional functionary when taking decisions in the times of crisis. This is what God, that is what the Dr. Justice Chandrachud said. It is the soul of the constitution. Next, K.S. Puttaswamy versus Union 95. This is the Aadhaar case, in which also the Supreme Court said constitutional morality is the essential component of rule of law. Rule of law is dependent on our constitutional morality. That is what the in this case said. Justice Abdul Nazir, who was also the Supreme Court judge, he said it is the constitutional imagination of moral citizen, moral community, and moral nation. So constitutional morality is in imagination of moral citizen, moral community, and moral nation. So morality is engrossed in entire political system. It is the people, it is the administration, it is the governance as such. Entire administration, entire governance is engrossed by the constitutional morality concepts. Now, coming to the going by this definitions, what are the facets of constitutional morality? That is what we just will look into it. One is constitutional morality is it is a constitutional temper. It is a constitutional method for achieving socio-economic objectives, that is the welfare of the people, respecting the diverse plural society, respecting the process and procedures, not just taking decisions as per the procedure, as per the process as such. Secondly, enforcing obedience to law by citizens. Enforcement obedience to law should be enforced. Third one is it is an unrestrained censure of authorities of the public authorities, whether it is the ministers, chief ministers, whatever public authority, they have been censured unrestrained authorities. Self-restraint is necessary condition for the maintaining freedom. So the crux of the this constitutional morality is they should not be any arbitrary act. Any act, it should be as per the rule, not arbitrary acting or arbitrary taking decisions. Next one is determining the form of administration. This is what Dr. Ambedkar said. Ambedkar says it is perfectly possible to pervert the constitution without changing its form, but by merely changing the form of administration and to make it inconsistent and opposed to the spirit of the constitution. So constitutional morality is necessary because even without changing you can change the administration. So in the absence of constitutional morality, this can happen. That is why he says constitutional morality is very important. If you don't have constitutional morality, administration can, without changing anything, it can be made a different kind of administration. That is what Dr. Ambedkar opined. Next comes constitution needs to be cultivated, and allegiance to the constitution. That is, in obedience, loyalty to the constitution. It is non-transactional. It cannot be transferred to someone else. It is to be, everyone has to practice this kind of reverence, respect, loyalty to the constitution. And entire community, the spirit of the constitution should be spread into entire community, because not only political actors, not only constitutional actors, the common man, common citizen also should have know the spirit of the constitution. Then only there will be proper governance and proper development of the society as such. And this is necessary to mitigate the evils of maladministration and its practice, like corrupt practices, like favoritism, nepotism. This all can be mitigated once you have the spirit of constitutional morality while taking decisions, while running the administration. This is required. Then it is this scrupulous application of rule of law. Rule of law, we all have studied A.B. Dicey's famous concept of rule of law. He says it is the supremacy of law, not rule of men. That is basic crux of the rule of law. So we should not have rule of men. It is the rule of law. One rule is means it should be applicable to everyone. There should not be any arbitrary application, and equality before law and legal spirit. This is what A.V. Dicey in his famous rule of law concept he has elaborated. That needs to be followed. That the constitutional morality expects that needs to be followed by everyone who is operating the constitution in their day-to-day affairs. Next, reverence for the constitution needs to be followed by public persons and manning the institution. Everyone, that is what I said, public and even governing elites all have to follow this spirit. So then primacy of public interest. So there should not be any private interest. It should be always the public interest should prevail in taking decisions or in running the administration. That is what the emphasizing salus populi supreme lax. This is the welfare of people is the supreme law. That is what the constitutional morality expects everyone who is working under the constitution. And respect for citizens' rights, adherence to institutional integrity. Institutional integrity, I'll come in the next this thing. This is only to constitutional morality required to maintain institutional integrity and inculcation of accountability on daily and day-to-day basis, periodic basis. So this is what required. And decision making with solemn and sincerity while taking decisions by the government officials, by the government political functionaries, they should take with solemn and sincerity, aiming always at the public interest. There should be an iota private interest in taking in their decisions. Lastly, Ambedkar says it is the soul of the constitution. There should be purity of action. And hostile to any personification of political authority, shun any hero worship. So the crux of the constitution is that there should be constitutional worship rather than hero worship. You worship the constitution. That is the primacy in the Indian political system. No hero worship as such. This is what the constitutional morality explains and advocates from the all persons, whether it is the governing people or it is the people, whether the legislator, prime minister, minister, chief minister, governors, and president, everyone. That is what the constitutional morality expects. Next, coming to how to approach the study of constitutional morality. Constitutional morality can be studied based on the foundational ideology of a political system. Political system's foundational ideology are there. In monarchy, we have what the king is supreme. Their different morality will be there. In liberal democracies, there is a separation of power. People's rights are the supreme. There, the constitutional morality ideology is different. In theocratic regimes, there it will be based on religious practices, religious principles. There, the constitutional morality is different. In dictatorial regimes, there is no rights at all, only authority and this thing, and enforcing strict obedience to the authority. There is no personal freedom. In communism, no rights, only pursuing the communist ideology. So, depending on the foundational ideology of the political system, constitutional morality is understood and is practiced. So, since India is a political liberal democracy, we have the separation of powers, we have the citizens' rights, and people are supreme. So this liberal political culture expects constitutional morality in the spirit of the constitution rather than any other spirit that prevails here. So second one is how to look into it. Latent and manifest, I have made it. Latent and manifest in the sense, we have all studied maths at our high school level and even up to PUC level. We have seen theory and theorems. Theory is one part, theorem is another part. Theorem is nothing but realizing the theory part. That is what reasoning, what a theory says in step by step, that is called a theory. Like that, constitution is a legal document that needs to be practiced, that needs to be understood in a functionalities, how it is functioning, how the constitutional actors are functioning. So this needs to be theory and practice needs to be go hand in hand. That is what the latent and manifest functions of the constitutional morality that we will be looking into it. Next, coming to the Indian scenario. Indian scenario, our latent constitutional morality is where is you have to see the constitutional morality. Our foundational ideology. our national movement and constitutional developments. We have national movement, which was mainly on the non-violent way, secular practice, truth, self-rule, Swaraj, rights, equality, freedom, self-rule. These are all our values which we advocated during our national movement. Our all leaders, people were all after these all values. So these are values are our core values, all foundational values of the constitutional morality. Likewise, we can go to the Constitutional Assembly debates. There also the things, the discussion is on the separation of powers, discussion on the fundamental rights, discussion on the powers and functions of the government, structure of the government. These are all, these give us the values of these constitutional moralities, which we have to look into it, which we have to practice in our day-to-day affairs, basically all citizens. And more important, so the political functionaries, the constitutional functionaries, they have to obtain. Then comes, we have the preamble, which gives the vision, which gives the values of our society, our political system. That is, we the people of India, having solemnly resolved to constitute India into sovereign democratic republic and to secure all citizens this justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them. So here they are telling all the rights. And republic, as they are saying, we are constituting a republic, not a hereditary monarchy as such. And basically, the constitution intended through preamble, it says we want to secure people all these for making them realize their self. That is what this. And what is the source of all these things? Constitution, they start with we the people, means we the people of India are the source of the constitution. They are the source of the power of the constitution. This needs to be always reminded by all of us, all, particularly the people who are governing us. They should be, because they are not the authority. It is the people are the authority. They take the power of the people. That always they have to give it back to the people in whatever better way. That is what the this preamble envisages, and the people have to look into it. And the fraternity, this is more important thing, fraternity, assuring the dignity of the individual. So this is what the everyone has to look into it, and unity and integrity of the nation. These are the very important core constitutional values which needs to be imbibed by everyone. It needs to be practiced by everyone. Dignity of the individual, unity and integrity of the nation. This is of prime importance for everyone, for the people, citizens, for the governing function, like the legislators, representatives, or the ministers. Everyone has to look into it and has to practice this one. Next comes the fundamental rights, which is the citizens' rights needs to be respected, needs to be, allowed to practice. This is what the constitutional morality expects. Then comes to the basic structure doctrine by Keshwanand Bharati case, which I already told you now. So next comes judicial review, democracy, free and fair elections, adult franchise, multi-party system, rule of law, independent judiciary, equality. These are all the unamendability of the basic structure. This cannot be amended. This needs to be followed, everyone. And constitutional morality expects that respecting all these values is the basic thing for everyone. Then comes one more interesting is oaths under the Constitution, under third schedule, under Article 60, under Article 159. There are different oaths are there. That I will discuss when in the next few slides, after the next slide. So coming to the constitutional morality, the term appears in the Constitution only 2 times. One in Article 19, where the freedom of speech is there. Another in Article 25 and 26, which pertains to freedom of religion. So constitutional morality as such word is not there. Only 2 times it is been practice. It has been brought in the Constitution. Otherwise, the spirit is pervasive throughout the Constitution. It is throughout the Constitution. Everywhere that constitutional morality spirit is, that needs to be followed. Next comes to the manifested constitutional morality, behavioral and operative aspects. This is the core principles, core values of constitutional morality. How these have been practiced, how these have been brought into practice by the various constitutional institutions like Parliament, by the governor, by the president, by the speaker, by the election commission. All these needs to be examined. But I am now taking only one, the parliament, because all these needs to be examined separately. I'll be taking only parliament as such, how the parliament is being functioned in the framework of the constitutional morality. Whether are they following the constitutional spirit as such, or just they are going by the legal requirements. This is what needs to be understood. 1 minute. So Parliament, first speaker G.B. Madvankar, he set the tone for the functioning of the Parliament. He made us then Parliament an independent institution. It is not to be seen as an extension of government or the party. It is an independent institution under the Constitution. It needs to be understood and allowed to function like that. It cannot be made as another department of the government. It otherwise, one city, if it loses its separateness or its uniqueness or its identity, separate identity, then it will lead to a lot of problems. That is why he said, if we go by merely by majority, we shall be fostering the seeds of fascism, violence, and revolt. So this is what the Mavlankar says. During his time only, when first Prime Minister Pandit Jawaharlal Nehru was there were 17 ordinances issued bypassing the Parliament. He made the Prime Minister that this is not a good practice. You cannot go for ordinance like this in a bulk way. It has to be made through the bill, through the parliamentary process only. So he made this kind of remark to the first Prime Minister only. But Nehru was in fact was more democratic and more interested in maintaining the constitutional morality of the Parliament. But if you see the first amendment, there is a lot of dilution of this constitution spirit by the Pandit Nehru as such. So I am recommending one book to you. This is the 16 Stormy Days, the story of First Amendment by Tripurara Daman Singh. How the Nehru manipulated, how Nehru brought in the First Amendment against the wishes of the Parliament as such. This you can see how the constitutional morality has been diluted by Nehru himself in those days. Next come to the Prime Minister Indira Gandhi. She almost reduce the spirit of the role of the Parliament in policy making, because government was made supreme. These all the amendments, emergency provisions we all have now, every day we hear it. And so this is the Parliament, the legacy is continuing. And Parliament is very important because Parliament functions, main function is ensuring accountability of the government. Accountability is ensured through various instruments of the Parliament. There is a question hour, there is an adjournment motion, there is a call attention motion, there is a bill, there is a budget. All these instruments provide the MPs to question the government, question the governmental policies, governmental actions, governmental omissions commission. This needs to be examined. So before that, how many days the Parliament functions, that is more important. If it functions more number of days, so there will be more number of time, more number of instruments can be used to question the government, ensuring the accountability of the government. Now coming to the number of sittings, on an average, see, first Lok Sabha, there used to be every year 135 days the sittings used to be there. Now coming to the 17th Lok Sabha, that is last 2019-24, it is reduced to 55 days. See how the sittings of the Lok Sabha have been reduced drastically. 135 used to be there in the first Lok Sabha. Now it has come to 55. It is less than 50% of what the Parliament used to sit during the first session, first Lok Sabha. So this is the implication, because when you are not meeting, when you are not assembling, when you are not sitting, there is no question of accountability, no question of any instruments like the question hour, adjournment motion, bills, budget. All these needs to be, there is not much time to discuss. So this is the basic problem here in the Parliament. So number of sittings have been reduced drastically. So it is it creates a problem for the ensuring accountability of government. Government, it looks at government in the over the last from last taking from the 8th Lok Sabha or 9th Lok Sabha or the 10th Lok Sabha, the governments have taken the parliament to the right because they are not meeting regularly. They have reduced the number of sittings. By that way, the accountability of the government is also reduced. Parliament, they take it for granted. This should not happen. Parliament should meet fully to ensure that government's actions, governmental omissions commission can be questioned and can be brought into accountability or answerability. That is what they expected. Next comes the bills. Bills, there is a in 2014 there is one public policy. They have a pre-legislative consultation policy of 2014. So before the bills are introduced in the parliament, bills are put to the public into public domain for public reactions, public inputs, public notes, and all these things. Now I have taken this from since 2014. There is 301 bills were passed, out of which only 227 bills were put on the public domain. So public, they have not. Out of that, 74 bills are placed in public domain for comments. At least 40 bills did not adhere to 30 days. 30 days time should be given. That also not given. So parliament and the government, they are not taking the public into confidence. This is what they made the policy, to have the public inputs, public response for the bills, but that is not been adhered. So this is where we require the constitutional morality. But is it right thing to do such things when you make a policy but you are not following the policy? What is right or wrong, you have to take decision. You see, as teachers of political science, you take decision like this. Now coming to the passing of the bills. For example, average 10 minutes to pass the bill in Lok Sabha in 2020. In Rajya Sabha, it is less than an hour. So in 10 minutes, you are passing the bills. What is the discussion? What is the title of the bill? What is the content of the bill? What is the objective of the bill? What it ensures? What it wants to do? How can one understand? How can one discuss? How can one deliberate on these matters? So this is a very sad affairs. If you are passing the bills in such a hurry, then all the MPs have just like the cogs in the machine. They have to just say yes and pass the bill. So important bills are passed, like the farm bills. We had 3 farm bills which were withdrawn, but they were passed without any discussion. This is the very serious question, because when you put a bill into the discussion, the members will get about to discuss on the bill, discuss on the various angles of the bill, various perspectives of the bill, its the utility, its lacuna, and its improvement. All this can be discussed by the MPs, member of a parliament. But when there is no time to deliberate on these matters, so bills become just like in the machine. You pass the bill, like the parliament becomes a machine, just say yes and pass the bill. So here, like, is it the right thing to do that one? When you have the procedure to pass the bill, there is a first reading, second reading, third reading, like this, the readings are there. All these needs to follow. So that is what I am telling you. I am not making a judgment. You make a judgment whether passing a bill in 10 minutes, is it a worthwhile? Is it really in accordance with the constitution? Then coming to the committees, we have a number of committees in the parliament. Committees are there necessary to scrutinize the bills, because in the parliament you may not get much time to discuss on a technical matters, legal matters. Some thorough discussion is not possible. Only in a committee it is possible. That is why committees are being made, because in committee you can call the experts, you can call the others also, and take the inputs from that. But referring the bills to committees are so reduced. For example, in 15th Lok Sabha, 2009 and 14, there is 71% of bills referred. In 16th Lok Sabha, there is only in 16th Lok Sabha, 21% bills are referred to the committee. In 17th Lok Sabha, there just 16% referred to the committee. Means without going to the committee, without thorough discussion, the bills are brought to the parliament and they are passed. So when you have committee system to go through the bills, thoroughly from all perspectives, from all aspects of the subject can be studied. But that has been avoided, that has been bypassed by the government, and now the bills are been introduced directly to the parliament and pass it. For example, abrogation of Article 370, and some of the bills have been women reservation bills. Some these bills have been not at all brought to the committee, immediately introduced, and they passed the bill. So this is not a good, like that economic weaker section reservation bill. So this bill and the IPC, CRPC, which evidence which have been brought into the Indian names and Bharatiya Nyaya, these all now been not been discussed thoroughly as such. With regard to EWS relation bill, I will just tell one small information. On January 6th, the minister says there is no issue before we are not bringing any economic reserve weaker section reserve bill, but he brought it to the Lok Sabha, Raj Sabha, and it is passed in 6 days. Just it became an act. Such an important bill which has implications for the society, which has implications for the political system, which was brought and discussed and made the act within just 6 days. There is no worthwhile discussion at all. So this is one aspect which needs to be pondered over. We have to think over on these kind of things, whether parliament is functioning as per the constitution, as per the expectation, as per the righteous path, as per the in an objective manner. This needs to be thought over. This needs to be pondered over by all of us. Next, come to the rise of walkouts and disruptions. Rise of walkouts and disruptions. Why the walkouts and disruptions happens? See, walkout and disruptions happen because there is a mistrust between the government and opposition. There is the government it fails to take the opposed into the confidence. These kind of walkouts and disruptions happen. There is the mistake. There is the perceptionally difference of opinion between the opposition and the government. Then these kind of things happen. So the implication of this is in 14th Lok Sabha, 13% of its working time is lost because of the disruptions. In 15th Lok Sabha, 30% of time is lost. In 16th Lok Sabha, 16% lives. So this time is lost. We are not getting time to discuss on the bills. When you make the walkout and disruptions and all these things, again the parliament is not functioning as per the constitution, as per the expectation of the people, as per the spirit of the constitution. The parliament is not functioning. This is what this indicates. So we have to think on this. We have to see whether it is a rightful way of doing the functioning of the parliament as per the constitution. This needs to be pondered over. Next comes to the recently ruling party resorting to disruptions. Earlier, there used to be disruptions and walkout by the opposition parties. But now, disruptions and disturbs even the ruling party people. Normally, earlier the conventions where the ruling party people used to keep silent, whereas the opposition party used to make their views boldly with disruptions and all this. But now the usual whataboutery means counter allegations, recriminations, all these things happening, which makes the parliament, in the sense, not true sense of the constitution, parliaments are not able to function. This is what is expected. And now coming to the speaker's bias conduct. We had the very good speakers in the earlier days, like the Balvankar and even second one I forgot. They were very good speakers. Speakers' conduct is very important because speakers are like the umpires between the government and opposition. If they function properly, then the opposition will have the confidence in the house, confidence in the government. This is what is required by the speaker. But if you see the day-to-day proceedings recently, nowadays, now the parliament is in session. Last week you see, earlier also you see, speaker's conduct is biased. I just give one small example which I have seen in the Lok Sabha, this TV. One Abhijit Banerjee, a TMC MP, was making a speech during the budget. Regarding the budget, he was making comments on the demonetization of the demonetization policy of the government. Then speaker says, don't talk about the earlier things like 5 year things, don't earlier things, you don't talk like that. But the speaker, same speaker, allowed the ruling party people to speak about the emergency, speak about the earlier Congress policies and all. So when you allow the other ruling party people to speak in the earlier things, when you don't allow the opposition party to speak up the earlier things, then it shows that speaker is not unbiased. He is not impartial. He is acting in a biased manner. This is what it looks from the TV screens, what I have seen in the Lok Sabha proceedings. So this kind of biased conduct of the speakers is not augur well for the constitution, for the functioning of the parliament as such. One more thing, speakers' biased conduct is certification of money bills. We have the money bills for various tax expenditures and all this. The money bills have been provided under Article 109 and 1110. So 1110 defines Article 1110 defines which are the money bills. So the authority to certify the money bill is the speaker. Speaker says this is the money bill, means nobody can question it. It is a money bill. But this provision has been misused by the speaker. Here also, for example, Aadhaar amendment was passed, making it as a money bill. So there was no money matter at all involved, but still it is passed because to bypass the Rajya Sabha, this was certified as a money bill. So this kind of conduct by the speakers does not augur well in the spirit of the constitution. This is what we need to think. Whether the speaker's certification of money bill, is it on the right path? Is it in an objective manner? Is it in the true spirit of the constitution? This needs to be understood and needs to be like that. In the appointment of heads of tribunals, some tribunals, they are making appointments, that also considered as a money bill. So that was passed. So this is the things, so many things. This is blatant. It looks, it is a blatant violation of, it appears it is a blatant violation of rule of law. So speakers' conduct in these matters needs to be evaluated, needs to be assessed in the spirit of the light of the constitutional values and constitutional principles. Next comes to the suspensions of members for misconduct. We have there is a rise of suspension of members from the parliament. Of course, members also do some wrong. Members also commit mistakes. All these things are there. But conducting the house by the speaker with magnanimity, with taking confidence of people, opposition, and everyone is the basic skill that speakers have to imbibe, and speakers have to do it. But the suspension is on the rise. You see, 2004-9, there was only 5 suspension. 2009 and 14, 45. 2014-9, 81. 2019-2013. In December 2023, there are grossly 146 members were suspended from the parliament. This kind of actions, this kind of suspensions does not augur well for the parliament, functioning of the parliamentary democracy as such. So this is not in tune with the constitutional morality, constitutional spirit, constitutional values, the values enshrined in the preamble and values enshrined in our constitution as such. Coming to the 2018 budget session, Lok Sabha passed 2 bills and 218 amendments without any debate in just 13 minutes. So there is no debate, no deliberation. Means Parliament is meant for that. The debate and deliberation are the backbone of Parliament. If you are not having a debate and deliberation, then Parliament has no, this is just a house, then you have to be mechanically if you are doing it. It is not in the spirit of the Constitution as such. And in March 2013, Speaker exercised guillotine. Guillotine means bunching of bills. Voice vote without aid. You bunch 3-4 bills. Then you put for the voice vote and pass it. So not single bunching the 4-5 bills into one and pass over the voice vote, not even divisions, not taking these things. So this kind of behavior from the constitutional functionaries, political functionaries, is not in the spirit of the Constitution. Constitution expects that you should work as per the democratic norms. So this is what the required. And coming to December 2018, 18 bills passed in the absence of power. When the opposition party members were suspended, they were put outside. So that time the 18 bills were passed. This is also not well. A convention is required. You bring the opposition back and allow them to deliberate and pass the bill. So these are the things which needs to be thought over, pondered over by the all of us. Whether is it a righteous course, is it a right thing, or the is it in tune with the constitutional practices? Next, come to the Prime Minister's participation in the Parliament. So Prime Minister participation in the Parliament is very important, because when the Prime Minister participates in the Parliament, the prestige, the dignity, the deliberation, the debates will enhance, because people expect Prime Ministers to speak, and people expect Prime Minister to respond to the MP's queries. The accountability is ensured more through these kind of things. They said, let us see how the various prime ministers have performed their participation functions in here. So I have taken from the websites here. The Jawaharlal Nehru, he's named 256 times. He participated in his entire career as a prime minister. Indira Gandhi, 170 entries were there in her career. Morarji Desai, 34 entries. Rajiv Gandhi, 90 entries. VP Singh, 18 entries. Chandrasekhar, 12 entries. PV Narasimha Rao, 48 entries. HD Devegowda, 48 entries. IK Gujral, 18 entries. Vajpayee, 146 entries. Manmohan Singh, 110 entries. And the present prime minister, 66 entries. So it shows how the prime ministers are giving respect to the parliament. We can give respect to the parliament in various ways, but this is the basic way. Your participation in the parliament is more important than other symbolic respects. Symbolic respects like the bowing to the parliament steps or bowing to the constitution document is also important, but more than that important is your prime minister participation is more important. Prime minister response to the MPs, because there we find the government's views, there you find the government's answerability, government's accountability is provided. So government's indifference, particularly prime minister abstaining from parliament, is not in tune with the constitution, because parliament is supreme house established by the constitution. That house you need to give respect by your participation, by your response, by your way of responding to the queries of this thing. But there is no such things. So in the Manipur problem, in the breach of parliament breach of security problem, the prime minister, neither home minister, they came and responded to the queries of the MPs. So this is not in tune with the constitution. Is it a right behavior or right thing? You think over it. For example, I am giving in UK in February 2018, one Lord Michael Bates, he was the Minister for International Development, came 5 minutes late to answer in the House. He took the moral responsibility and resigned. He said, I was to come and answer at 10 o'clock, but I came here 10:05. This is my response. By coming late, I am resigning. This is what the spirit of the constitutional morality is required. Nobody has to say it is you have to imbibe the culture of constitution among us in our mind, that we have to give respect to the constitution by way of participation, by way of responding, by way of participating in the process and procedure of the constitution. This is what required, but that is not found in a major way presently now. That is why because of disruptions, because of these things, because of the walkouts and all things, Somnath Chatterjee, who was the speaker during 2019, he said to the MPs, he made a remark to the MPs, I am sorry, I have to say that you are all working overtime to finish democracy in the country. I can only say you are behaving in the most despicable manner. The whole country is ashamed of its parliamentarians. Because of the walkouts, because of disruptions, Somnath Chatterjee, he made this statement. So this is the sad state of affairs by the behavior of our MPs or the political functionaries involved in the parliamentary process and parliamentary practices and procedures. So this is what the parliament. So these all show that the role of parliament is being reduced, because it is a supreme institution which has to decide the fate of the people of country, fate of the nation. But the role has been diminished because of reduced sittings. Sittings have been reduced drastically. Passing the bill without discussion, no deliberation, reduced the reference to the committee. There is no thorough discussion at all. rise of walkouts and disruptions. These are number, suspension of members in large numbers, and passing of bills in the absence of opposition. So these all factors make the parliament role, minimize the parliament role in the governing of the country, because parliament is where the bills are passed, where the fate of the people are decided, where the future of the country is decided. But there it is been reduced by all these actions. So this needs to be thought over, this needs to be pondered over by all of us as citizens of India, the teachers of political science. So what are the implications of this trend? This implications of this trend is executive becomes very strong and authoritarian. Parliament and executive, judiciary all have equal, but here reducing the role of parliament, again executive becomes the authoritarian. Secondly, it reduces the accountability of executive parliament, because when you have no sittings, when you have no bills, when you have no question hour, when you have no adjournment motions, there is no question of accountability to the parliament from the executive. Then parliamentary wisdom is lost. We have seen earlier the great debates in the parliament. That debates are missed. Now only walkout, disruptions, and crisscross talking. All these things are so. The parliamentary wisdom is lost by this kind of. So when MPs have become pawn in the parliamentary politics, they are like the chess pawns. Just you come and sit and say yes to the all bills, yes to the all budget, and go. So like that, mechanical how to do work. This has become. That is why former RBI Governor Bimal Jana, in his book says it. Parliament has become a pro forma parliament, because you have to do pro forma, fill the pro forma and get the pass, like the budget pro forma, pass it like that. So this is what. And it has a democracy index. It is a flawed democracy. Democracy has become to that extent flawed. It is moving towards electoral autocracy. So you have elected government, you think, but the parliament is not functioning in the spirit of the constitution, means it needs to be thought over. Then people's rights and grievances leaders are in danger. So when the parliament is not functioning, ultimately people's rights are affected, because executive, nobody can question executive and government. Only in the parliament you can question all these things. So people's rights, grievances are at danger, are at peril, I can say it. And development initiative by the MPs or the people are totally missed, only because the government and executive initiative, all the development initiatives, it's only the government's wisdom rather than parliament or the people's wisdom is prevailing. This is what the functioning of parliament shows, and how the constitutional morality is being eroded, is being bypassed, are being not followed. This is what the functioning of parliament shows. Next comes to the oath. I'm taking here oath things. Oath is a universal statement. It serves a symbolic commitment that person taking public office will affirm to uphold the law. It's moral commitment between public official. So it is a moral commitment between the public official and the people. It places great responsibility on the public official. It is a symbolic deed. It is like a deed, like the property deed. We say it is symbolic deed. You are making a deed where the public interest values are outweigh the private interest values. So oath, people are the political functionaries taking oath. They just take a deed that they were taking. We are giving importance to public interest. It is a great responsibility we are taking. We are doing, giving a moral commitment to the country, that we are functioning like in a public spirit as such. That is why James Madison in his Federalist Papers says, if public servants were angels, we would not need oaths, code of ethics, other public laws to hold individuals accountable. If public servants are like God, we will not ask them to take oath, because we believe that God will always do good things. Since we are public servants, are not God, are not angels, since they are human beings, there is all possibility of they may slip into the bad behavior. That is why public servants are not angels. We need other tools to ensure higher standard of moral character from public servants. Violation of oaths lead to public censure, prosecution, and resignation from the public office. If violation of oath is not punished, others and subordinates imitate and mimic unethical behavior, Further, in the public integrity. So constitution, this is what the medicine says. Constitution provides oaths to president, vice president, prime minister, central minister, Supreme Court judges, governor, chief minister, state minister, MPs, MLAs, MLCs, and before taking the elections as the election candidate, and all so many votes have been given in the third set of the constitution. I am taking only two votes here for just discussion, just to throw before you the questions. One is the Article 60, oath by the President. This is President take oaths before the Chief Justice of India. I swear in the name of God that I will faithfully execute the office of the President of India and will do the best of my ability, preserve, protect, defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of India. This is the President takes oath before entering the office. Then comes Article 159, wherein the governor of the state will take the oath. I will swear in the name of God that I will faithfully execute the office of the governor of so and so state, and I will do the best of my ability, preserve, protect, and defend the Constitution and law, and that I will devote myself to the service and well-being of the people of that state. So there are only two constitutional functionaries, one governor and another is President of India. They take oath to defend. They take the oath to preserve, protect, and defend the Constitution. So this is very important. Why I'm important telling you, I was secretary to the governor of Karnataka for 2 years. That time, President of India was the Pranab Mukherjee. He used to take a video conference for all the governors, and he used to advise all the governors with this oath. He used to say only president and governors are taking oath to preserve, protect, and defend the Constitution. That is why your behavior, your action should always be guided by this. That is the preserving, protecting, and defending the Constitution of India. This is what the Pranab Mukherjee used to advise all the governors through video conference every 6 months. Every 6 months. So now let us coming to the recent governors' behaviors. We all have seen it, how the governors behave and all. Whether their behaviors are really preserving, protecting, the defending the Constitution, particularly non-BJP states. There is a clash, there is a tussle between governor and elected governments. You take the Kerala, you take the Tamil Nadu, you take the West Bengal, you take the Delhi Lieutenant Governor, you take the Telangana, you take the Jharkhand, you take the Maharashtra non-BJP government, you take Chhattisgarh, you take the Punjab. You hear every day there is a lot of clash between the elected government and the governor. So whether the governor's behavior in these non-BJP ruled states, BJP ruled governors, I have no problem at all. Only the non-BJP ruled states, the governors have the tussle between the elected government and the governor. Are the governors are really acting to preserve, protect, and defend the Constitution? You just decide over it. You just think, because already the matter has been decided by the Supreme Court, and now the government of India is referred to for the Supreme Court through the presidential reference under Article 150 or something like that. I don't know. So that is there already is in the process. So these kind of governors' behaviors, is it in tune with, is it in the spirit of the Constitution? To having taken the oath, defend, preserve, defend, and protect the Constitution, are they really acting in this manner, in a rightful way, in a constitutional way, in a principled way? This needs to be understood. This needs to be thought over. It needs to be intellectually verified, intellectually exercised, these kind of things. So I am asking you people to just think over on these things, because I myself have served as the secretary to governor. I have seen all these things. So that is why I'm asking you to ponder over and think over on these things. That is why Justice Chandrachud, during this case, he said governors should soul search their behavior. They should think that they are not oblivious of the elected government. Oblivious means they should not be unmindful of the elected government. When the elected government is in parliamentary democracy, elected government is supreme. Governor is a constitutional nominal head. So when there is an elected government, you think that mind, you have in the mind that elected government is functioning. So your role is minimized. So that kind of thing. So whether the governor's behavior in the recent 4 5 years, you have seen Tamil Nadu, Kerala, you have seen West Bengal, you have seen Chhattisgarh, Punjab governor, in fact, blackmailed the elected government earlier. So these things are happening. Are these governors are really functioning in the spirit of the constitution, spirit of the oath they have taken? They have taken the oath to preserve, defend, protect the constitution. Whether are they doing it, that you just think over it. Next, come to the third scheduled ministers of the union, and same like that is there. Here the one oath is, I do swear in the name of God that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will uphold the sovereignty and integrity of India, that I will faithfully and conscientiously discharge my duties as a minister for the Union, and that I will do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. So here, this is the oath taken by the Prime Minister, central ministers. In a similar manner, the state chief ministers and the ministers take the oath. I am just underlying here, they have to have bear the true faith and allegiance to the Constitution of India. First, they should have faith in the Constitution of India, loyalty and allegiance to the Constitution of India. Secondly, they have to do all the manner in accordance with the Constitution and the law, and without fear or favor and affection or ill will. So here they are ill will. I am taking the ill will. Ill will is what? Without hostility to the people, without dislike to the people, without disliking someone or something, or negative sentiment to the people, you have to work. So this is what they expect by the union ministers, union prime minister, central chief ministers, and all. They have to work for the purpose as per the constitution, as loyal to the constitution, allegiance to the constitution, and without fear or favor or affection or ill will, without affection or ill will. So whether our ministers, our prime minister, our chief ministers, are they working in the true spirit of the oath they have taken? Whether they are ill will, hostility towards or dislike towards some people, are they really working? So I have taken there is the one report, is the hate speech report 2024. This has been done by Center for Study of Organized Hate, Washington, D.C. They have made India Hate Lab report kind of thing. They have listed how many people have made hate speech, hate towards some people hating that. Is it not ill will? Is it not the violation of the oath they have taken? For example, Yogi Adityanath has made highest number of hate speeches. He is the chief minister of the Uttar Pradesh. He has made the highest hate speech. He has taken oath to work without fear or favor or affect or ill will. So that kind of things are happening. Like that prime minister, like that home minister, like that Hemant Biswa Sharma, like many other things. There are a number of this hate report. You will see it. How many times the hate speeches have been made by these people? Hate speeches, for example, they have given statistics. In 2023, there were 668 hate speeches. In 2024, there is 1165, 1160, more than double hate speeches have been increased. So this is, they have taken vote that they are not disliking any people. They are not making any ill will statement, but these hate speeches are on the rise. Are our political functionaries, are our constitutional functionaries, are they doing their functions, are performing duties as per the oath they have taken, as per the constitution they have taken? This needs to be whether this kind of speeches are, is it right in the spirit of the constitution? Not only constitution, but there is also, we have got representation act. We have so many other rules, acts are there. They're all there. But are they following? Are they going as per their oath? They have taken oath, means they have to perform as the oath. They take the oath. So this needs to be taken. You can see the India Hate Lab report. That is from the Center for Study of Organized Hate. So that kind of things are happening. Whether our constitutional function taking oath and working or performing their constitutional function as per the oath they have taken, is it they are doing it? Is it the right way or in a constitutional way? You need to think over it. Where is the what is going wrong? Whether constitution is wrong, whether the person are wrong, who is wrong? You have to think on these lines. And as a teacher of political science, we have to think on these lines also, because we study constitution, we teach constitution, we teach oaths. This is not just a formality. This is your commitment. It is a moral commitment. It is a moral deed that you are doing the work as per the constitution, work as per the benefit of people as such. So this is what is required under the constitutional morality. So now coming to some of the things I have listed here, the constitutional functionaries have one kind of constitutional amnesia, means they have forgotten, they have given a silent by go, means they are not taking these into constitution, into cognizance, like the Manipur disturbance and violence, non-filling of the deputy speaker post for the entire term 2019 and 14, security breach of parliament, confronting attitude and behavior of governors of non-BJP states, bypassing president at the inauguration of new parliament building, prime minister's no press conference last 10 years. These are all the things one should think over this. So with this, I conclude these things. I will have small conclusion in this. Undermining the constitutional morality is persistently going by from the days of Srimati Indira Gandhi. This is not a new thing. This has been happening from 1975 during emergency, prior to emergency also these are happening. So this is one way of eroding the constitutional morality. So it makes the impact on our state. That is what Miller, Vaishnava and Madhav Khosla in their article writes. Our liberal state has become ethnic state. It is absolute state, opaque state. It is ethnic state in the sense we have become the more on ethnic way of doing the things. We have governing the polity. Absolute means total control of the polity, and opaque in the sense citizens' rights have been affected. That is what this Ethnic Citizenship Act, absolute means abrogation of 360 70. Opaque means total control of media. That is suppressing all dissent, criticize the government, wants to disclose these things. So they say that ethnic means Citizens Act, CAA, absolute means abrogation 370, opaque is total control of media. This is what Milan, Vaishnava and Madhav Costa in their article I have cited, given the reference to the article, you can go into it. So Constitution is a sacred book for citizens as governing people. It reference, its respect is expected. Exhibiting constitutional virtue by the constituents is must. Constitution, apart from structuring the rights and governance mechanism, also emphasizes it is a sense of our history. It is a sense of self. It is a sense of Indian self. Indian self is being depicted in the constitution, is visualized in the constitution. That needs to be protected. So that is why, in the absence of constitution morality, the operation of the constitution, no matter how carefully written, tends to become arbitrary, erratic, and capricious. It becomes whimsical and impulsive. In a parliamentary democracy, the obligations of constitutional morality are expected to be equally binding on the government and opposition. Not only government, opposition, people are also binding. That is why in the spirit of the constitution, that is what Aristotle said, people, citizens should be educated in the spirit of the constitution. That is what required. And both needs to exhibit the virtue of civility, show tolerance, restraint, and mutual accommodation in public life. Shun whataboutery, counter allegation, reclamations. So UK practice is like the one day exclusive for the Prime Minister to question. That needs to be brought in here so that the opposition can get a better space in ensuring the accountability of the government. That is what is required here. And constitutional functionaries like Speaker, Election Commissioner, Governor should exercise their power in discretionary power as per the rule. These all needs to imbibed by the morality, has to imbibed with all these functionaries. That is why Lord Salisbury said discretion is according to rules of justice, not according to private interest. They have the discretionary things. Speaker has discretionary power, Election Commissioner has discretionary power, Governor has discretionary power. I told you, money bill, certifying money bill is a discretionary power. They can whatever they can say, it is money bill. But you have to, as per the justice, as per the constitution, you have to define it. You have to certify it. So they need to use their discretionary power, not in an arbitrary manner, in the manner of realizing the justice, in a manner of realizing public welfare. That should be the crux of the discretion, not the just private interest or the political interest. That is why rule of law is not against rule of numbers. Rights and wrongs of the issue to be decided in accordance with rule of law, not rule of numbers. What is right and what is right, wrong, what is justice and what is injustice, should be decided by rule of law, not by rule of numbers, weight of numbers. This is what Andre Patel says. Democracy requires institution to ensure that rule of law is not overruled by the weight of numbers. That is, we should always have the in the mind that the rule of law always, it should be prevail always, not the number as such. Constitutional morality is difficult to enforce in the court of law. You cannot have, because it's not law, it is a moral principle, moral precept, moral practice. Like the giving respect to the elders is our Indian culture. It is not law. You cannot go to the court of law. So it is also like that. Constitutional morality is a moral precept or moral principle. It needs to be followed. It cannot be enforced in the court of law. It is only by adhering to by the constitutional actors, constitutional functionaries like the MPs, MLA, ministers, Prime Minister, President, Vice President, Governor, all the constitutional functionaries, whoever they are working under the Constitution, they need to follow the constitutional period, constitutional values, rule of law. Then there will be better governance and better society. Ultimately, the conscience of the constitutional functionary should prevail. The constitution of the conscience, self introspection of the constitutional functionary is important. It needs to be imbibed. But the present situation, you think over it, how it will be. That is the last thing. Dr. Ambedkar quotation I end with this speech. Ambedkar quote, however a good constitution may be, those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implemented are good, it will be proved to be good. So constitution is good or bad depends on the people who are operating the constitution, not the constitution as such. With this, I